So I want to talk about a few of the most significant instances in which what was once condemned as right-wing radicalism has become Democratic Party policy under the Obama presidency. And as I said, I could spend several hours going one by one through all the instances in which these policies have continued, but I just want to highlight a few of them. And what's interesting here is that the point is not that these policies that were in place when Obama was inaugurated haven't yet been uprooted. It's not a critique that he's been too slow to reverse them. The critique is the opposite. It's that he has affirmatively embraced them as his own, and in many cases extended them far beyond where George Bush and Dick Cheney ever dreamed of taking them. So the first area that we find this to be true in is in the area of indefinite detention. The idea that you can take people, human beings, and put them into a cage for years, indefinitely, without so much as charging them with a crime or giving them any opportunity in a court of law to defend themselves or to prove their innocence, to contest the validity of the charges. This was the heart and soul of the controversy over Guantanamo, over Abu Ghraib, over the universal worldwide system of detention that was created under the Republicans in the War on Terror. The idea that we can simply on the president's say-so, the accusation, untested and unproven, that someone is a terrorist or is consorting with terrorists, put them into a cage for life without a shred of due process. And this controversy is typically talked about in the context of the closing of Guantanamo, where Obama ran for president, not as an ancillary promise, but as a central promise to close Guantanamo, and hasn't. And isn't going to. And if you talk to Democratic partisans and apologists of the president, what they will say is that the reason that he hasn't closed Guantanamo is not his fault. The reason is because Congress passed a law, or a series of laws, impeding his doing so. And that's not actually untrue. Congress did pass a series of laws barring the closing of Guantanamo in effect. But before that ever happened, the president's plan for, quote unquote, closing Guantanamo was not really to close Guantanamo at all. It was simply to move it a few thousand miles north to Illinois, where the aspects of it that made it so controversial, namely imprisoning people for life without due process, was going to be fully preserved and retained. Now, the controversy, at least as I understood it during the Bush presidency about Guantanamo, was not, isn't it so outrageous that George Bush and Dick Cheney are imprisoning people without due process on an island in the Caribbean rather than doing it in Illinois? So that if you just move it a few thousand miles north, controversy just diffused and problem solved. I think, as I understood it at least, the controversy was about the fact that it was profoundly unjust to imprison anybody without due process, let alone the thousands of people who had been imprisoned, especially since it turned out that the vast majority of them were completely innocent. And yet before Congress was going to act at all, the president announced that he intended to continue that policy, but to bring it onto American soil, which is arguably worse, since it could infect the entire judicial justice system. Another policy that Obama has continued and even worsened is the idea that even habeas corpus, the most minimal right that a prisoner can have that's guaranteed under the Constitution, it's far less than being charged with a crime, where you're charged with a crime and you get to go into court and the state has to prove beyond a reasonable doubt that you're guilty before it can punish you. Habeas corpus simply allows a prisoner to go in and make the state prove that there's some minimal evidence to justify the accusations against that person. And the Supreme Court in 2008, in one of the very rare instances where it actually imposed some limits on executive power, said in the Boumediene case that prisoners at Guantanamo have the right to habeas corpus. That's the only right they have. They don't have the right to be charged with a crime, but at least they have the right to habeas corpus, a one shot at getting into court and making the state prove that there was evidence, credible evidence, to justify the allegations against them. And since that Supreme Court decision was issued in 2008, 82 Guantanamo prisoners have gone into court asserting habeas rights, and 53 of them have won. And to win a habeas case, it means that the court finds, not that the preponderance of evidence is in your favor or that there's some reasonable doubt, the court has to find that there's zero credible evidence to justify your incarceration. And over 75% of Guantanamo detainees have been successful in their habeas cases since 2008, at the time when even the Obama administration was insisting that only the worst of the worst were at Guantanamo. Now, despite the horrendous record of not just imprisoning people without due process, but imprisoning obviously innocent people without due process, the Obama administration took the position that this right that the Supreme Court recognized applies only to people in Guantanamo, but not anywhere else that the US imprisons people, such as at Bagram in Afghanistan or in places in Yemen or any other places where the US maintains prisons, such as in Iraq. And the Obama administration has thus far won in court with this argument, meaning it has won the right to circumvent that Supreme Court decision that says that habeas corpus is a right that detainees have. If you're at Guantanamo, you simply don't bring them to Guantanamo anymore. Instead, you bring them to Bagram or you put them in Iraq, and that's what the administration has been doing. So thousands of prisoners continue to be detained, increasing numbers all the time, without a shred of due process as a result of this circumvention. Then there's the issue of one of the most controversial aspects of the Bush assertion of executive power, which is the warped version of the state secrets privilege that the Bush presidency developed and pioneered. And it's a somewhat technical doctrine, but it's critically important in terms of how it was being used and is continuing to be used, because it basically destroys the rule of law, literally. The state secrets doctrine was once, starting in the 1950s and then applied through the next several decades. It was a doctrine that said that in certain cases involving national security, in certain judicial cases, some documents may be so secretive that even though they're relevant to the litigation, even though they're relevant to the case, even though in all other instances they would be allowed to be used, some documents are so sensitive and risk triggering the disclosure of important state secrets that they can't be used in the case, even if they're relevant. And what the Bush presidency did was it converted this doctrine from a document-specific privilege that said certain documents can't be used, and they developed a new theory that said certain topics are so secretive that they cannot be the subject of litigation, even when the president is accused of breaking the law. And that was basically the tool that the Bush presidency used to shield itself from any judicial review for its actions, even the most illegal ones. And the Obama administration has continued this doctrine to the point where policies that Obama once condemned as blatantly criminal, like illegal eavesdropping and rendition and torture, are now, under his administration, declared to be such vital state secrets that they cannot even be the subject of judicial review, meaning even if the president broke the law, he can't be put into court and have a court find that what he did was illegal because what he did was too secret. It literally removes the president from the rule of law.